Judge Chutkan in the January 6 case coming out of the District of Columbia continues her election interference. This might be her last go because the clock is ticking. Trump continues to pull away from Kamala in the polls, and the Justice Department, via Jack Smith, the illegitimate prosecutor, are running out of options, running out of time. So they've got to smear Trump. And they raced to get this trial done before the election, tried multiple times to make it happen. Didn't happen because of that little problem of immunity that's existed in American law forever until the Democrats got in charge this time and decided it didn't exist. But then the Supreme Court stalled all this, stayed everything because they needed to process the case. There is immunity. Trial's not going to happen before the election. So now it's book report time. Jack Smith and Judge Chutkan colluding with one another. Jack Smith is not even legitimate, right? That's up for debate. Another equally powerful circuit dismissed him, and he's still prosecuting this case. And now they are dumping materials with weeks to go until the election occurs. And so Chutkan issued this order. We're going to read through the order, but let me get us up to speed on what Trump's people said, because Chutkan, I don't even know if she read this, essentially. They filed this on the 17th. You can see Trump's team submitted this on October 17th, 7-pager, and they asked for a continuance of the release of this appendix because Jack Smith already released his 165-page book report. And quite frankly, it was not that interesting. It was the same regurgitated nonsense, all conjugated in a way that was the most damning to Trump. It wasn't about the interest of justice or anything. It's just a smear job. And there were some redactions in there, but the appendices should be the conversations and the back and forth between other people that would, if they're released and unredacted, should give the media a bunch of stuff that they can salivate over for the next 2 weeks. So you can think of it as the October surprise from the justice system. And there's not much time left to do much else. Like, I think this is it, unless there's more appendices or more materials that they'll continue to drop. But my point is, Trump submitted this. Can we please continue this? We're in the middle of an election. The DOJ has manuals and other policies. They don't interfere in the elections. They're not supposed to be dropping materials that are going to be dispositive and push things one way or the other. So Trump said, hey, can you just temporarily continue the stay of your order? Remember, the judge came out and said, I'm releasing the appendix, but I'm going to stay the release for 7 days. They're saying, can you just continue that 7 days? Like, all right, just make it like 21 days. And then we'll be after the election. To allow for the concurrent, right? And now Trump is even making a fairness argument saying, can you allow us to provide our appendices? If you're going to drop your appendix from Jack Smith, who's not even a real boy, how about we can publish ours simultaneously with it? So he'll drop his and we'll drop ours. That sounds fair, right? Trump says, on September 26, Jack Smith sought leave to file its immunity brief and its appendix under partial seal. Now she's going to release all that. The special counsel represented that it had redacted non-public sensitive materials from their appendix in their entirety, but stated that the appendix still contained other, they say supposedly already public materials. And so again, then this is the government, like taking all of this public stuff. Just think about what is happening. They go through the Washington Post reporting and the DOJ report, the New York Times reporting, right? So the deep state, via the DOJ and everybody else who's been constantly prosecuting Trump, they regularly leak to the media, and they do that for tactical reasons to gain advantages in multiple arenas, the courts of law, the political arena, right, to create narratives and PR for their side. So they leak all of that. Then Jack Smith is going to go gobble all of that up, bundle it up, then put the stamp of the special counsel on it, and then file that in an official court document. And so they play off of each other. Then the media will again take that. They're like amplifying it. It reminds me of like in science class when you would enhance a bacterium or something, right? And then allow that to percolate in the little petri dishes. That's what they're doing. It's the same thing. They're taking something that's non-existent and they're just amplifying it over and over until it grows. Then Jack Smith will bundle it all up, deliver it right to Rachel Maddow, and she'll think that she can use it to be useful in her attacks on Trump. Although I think, honestly, a lot of this is backfiring. People are sick of it. Trump objected to the public release of the filings, arguing that the Constitution, as well as the rules of criminal procedure, do not permit Jack to preemptively defend its own lawless superseding indictment before Trump even objected to anything. So Jack is filing so Jack screwed up the first indictment because he had a bunch of immune conduct in there, calling it illegal for Trump to talk to his DOJ. What? He was the president. It's his DOJ. So he had to strip a lot of that out, then filed it again, a second attempt. And the judges, I guess, will accept it, even though we're here months away from the election. We'll let you try again. So he did try again. And then he filed another filing saying, I need an opening brief. For what? She said, yeah, great, because the Supreme Court said that we need it. And there are many other threshold issues that they could address, like immunity, before they went through this. If Trump is immune, then none of this should have been released. And he is immune. She just doesn't want to deal with that yet. Publication now of cherry-picked materials with Jack describes as a, quote, detailed statement of its case, which is trial in Chutkan's rigged docket is where we're having trial. Not in a court of law, in Chutkan's rigged docket. It would prejudice jurors and endanger potential witnesses, especially in light of the extraordinary media coverage that this case has received. And the election is less than 3 weeks away, Judge, and it's going to irreparably harm Trump. So then on October 2nd, Judge Chutkan overruled Trump's objections as to Jack Smith's redacted immunity brief and ordered its immediate public release, and we read through most of it. The incumbent vice president, whose administration the special counsel serves, that's Kamala, also began featuring Jack's brief in political advertisements. Wow, I didn't even know that. So she is referencing Trump. So see how sick these people are? They're going to lecture us all about democracy. And they're the same people. Kamala's office, Kamala's executive branch, which operates Merrick Garland, who's the Department of Justice Attorney General, hired Jack Smith, is not independent counsel. He works for Garland and then prosecutes Trump, and then Kamala is going to run advertisements.
Fight like hell. And if you don't fight like hell, you're not going to have a country anymore.
New evidence about Donald Trump's efforts to overturn the 2020 election.
I think we did see this one.
Bombshell after bombshell.
There it
Trump
is.
was pressuring Pence to take action.
Has betrayed the United States of America.
Look, that must be it, right? Right there. That's the document. 165 pages. See, there it is.
Trump looked at him and said only, so what?
That's Kamala's ad. Wow. So they're still doing that's wild ad. That's what they're hitting citizens with all over the country. They must be desperate. All right. So that's what they submitted. So Kamala is literally using her own administration's prosecutions against her political opponent in her advertisements. And then the Democrats are going to come out and lecture us about, we have to make sure we adhere to the Democratic norms. Are you nuts? Are you listening to yourselves? Thus, without any semblance of due process at all, including Trump's right to cross-examine witnesses, which you can't do in a piece of paper, and call his own witnesses in court, the public has been poisoned by a one-sided prosecutorial narrative that is being used for political purposes by Kamala and her administration. And so then after that, on October 10th, just a few short days ago, the court determined that the redacted appendix should also be released because Kamala's desperate, but stayed implementation of that order for 7 days to permit Trump to evaluate further litigation. And so that's what we're doing now, saying district courts possess inherent power to temporarily stay proceedings, Judge, and you can do this. Deciding whether to stay an issue is an exercise of judgment, which Chutkan has none. Here, Trump requests only, very only, that the court briefly continue its existing stay. Just continue it. I'm not asking for anything new. Just postpone it a couple weeks until after the election, such that the redacted versions of the appendix that they're planning to drop and Trump's forthcoming appendix, so Trump's response to Jack, can be released at the same time. Now, although this stay will not eliminate the harms Trump has already identified clearly, certain harms can be mitigated. For example, if this court releases Jack's cherry-picked documents, potential jurors will be left with a skewed, one-sided, inaccurate picture of the case. Those same jurors may not see Trump's later responsive filing, and even if some do, first impressions are prone to remain. And you don't get to cross-examine them like you do in court, right? In court, you have a witness come out, says a bunch of garbage, and you get up and you get to cross-examine them and get to prove that is garbage. And then they get to come back and try to rehabilitate that witness. It all happens in real time. Everything can be reported simultaneously, and that's it. Now, what happens here is Jack's 165-page dookie has been sitting on everybody's desk for weeks now, by the time Trump's going to have an opportunity to respond. So this is especially so as Chutkan also gagged Trump, unconstitutionally restricting his ability to even speak against this using his First Amendment protected political speech. He can't even publicly comment on this stuff. So Jack gets to say whatever he wants on the public docket, and Trump is gagged. Conversely, if the appendices are released simultaneously, if we do this fairly, at least some press outlets, not holding our breath on many, will attempt to report both sides of the case, reducing, although again not eliminating, the potential for irreversible prejudice. Now, similarly, Judge, the risk to witnesses will be somewhat reduced as the public will have a more balanced picture of their testimony and how it connects to the case. And the public interest here, which the court has previously relied on in making scheduling and redaction decisions, also supports simultaneous releases. And they keep saying, well, the public has to know that Trump's an insurrectionist. It's not election interference at all, because the public needs to know. Thanks. As the Supreme Court has held, the determination of immunity raises multiple unprecedented and momentous questions about the president and the limits of his authority under the Constitution. It's therefore essential that the public fully understand the arguments on both sides and that they're not being misled by Jack's one-sided submissions. Indeed, limiting the public's access to only one side of this debate would grievously harm its understanding of what's happening here. And moreover, Judge Chutkan, asymmetric releases exacerbate the very harms immunity exists to prevent, including that the prospects of criminal prosecutions chill the president from taking the bold and unhesitating action that's required of the executive. If, as here, an illegitimate prosecutor like Jack Smith, during a highly contested political campaign, is granted leave to submit enormous public filings examining a president's decision-making while in office, future presidents are going to be a lot less likely and more reluctant to take the, quote, bold and unhesitating action required of them. This is true even if ordinary procedures are followed, with the president making the first submission. But it is especially problematic, and Trump didn't file first. Jack Smith came out and says, Your Honor, I would like to just submit this brief. And Chutkan even said, it's out of order, basically, but we need it. And said, it's 4 times the size of a normal brief, but we want it. But is especially problematic where neither the Constitution nor the rules of criminal procedures that are based on our founding principles, which Chutkan flushes down the toilet regularly, have been followed, thus wrongly allowing the prosecution to file first in anticipation of our motion to dismiss. We haven't even filed that yet on this. Although, again, a stay will not eliminate these harms. It at least is going to bring these proceedings closer to a structure that's mandated by the law. And finally, Judge Chutkan, whether or not Jack is politically motivated here, he obviously is, the asymmetric release of these allegations and the related documents during early voting, we're literally voting right now, creates a concerning appearance of election interference, as noted by many legal commenters with vast prosecutorial experience. Jack Goldsmith said the same thing. Eli Honig also said the same thing. And Jack Goldsmith, I believe, if this is the guy I'm thinking of, I believe he's like a big deal in the DC circuit circles. Like everybody, what does he say? He's one of those. The department could have asked the judge to set the filing date after the election without affecting the prosecution, obviously, clearly. But it didn't need to disclose the new details now because it didn't need to. And because it was foreseeable that the disclosures would cause approximately half the country to suspect the DOJ's motives. Clearly, more than half now, as you can see in the polls. It's hard to understand any reason to go forward this close to an election other than to influence it. Yep, a motive that would clearly violate department policy, especially given the damage to the DOJ from its previous missteps against Trump. It's imperative the department explain in detail why this inference is false, why it's not election interference, and why its actions comported with past department practices and understandings. Obliterated, right? It's clearly election interference. There's no other reason to do it. Everything else can wait. If the election doesn't matter, then just do things in the ordinary course. You don't have to have Jack Smith go first. You don't have to have him drop unprecedented motions on unprecedented legal issues out of order. I bet the Supreme Court is furious. These concerns are particularly poignant given the incumbent Vice President, Kamala, her targeted and ongoing use of these proceedings and their false use of these proceedings in her elections, right? It's the petri dish. They seed it and then they just incubate it and it grows and grows. They leak it to the Times and the Washington Post. Then Jack Smith uses the public reportings. Then he puts the DOJ seal on it. Then it comes back out. It's more powerful every cycle it goes through. Now Kamala's using it in her ad campaigns again, right? It originates from her. Now she's advertising. Look, the DOJ. The Hill said Harris's campaign has made Trump actions on J6 a focus of her rebukes against him, arguing that he's a threat to democracy as these people prosecute their political opponents. It's outstanding. Now, although the court has decided over Trump's objections that the political consequences of these proceedings is not a cognizable legal prejudice. So the fact that we're interfering with the election, that's not recognized in our system as being prejudice to you because it's never happened before. The court has not addressed the public's interest in ensuring that this case does not unduly interfere or appear to interfere with an ongoing election. A temporary stay by just postponing this a bit would serve that interest by ensuring that the appendix is accompanied by Trump's rebuttal so that Trump can respond in real time, reducing, again, but not eliminating this case's improper impact on the election as well as the potential for voter confusion. Additionally, a stay would promote public confidence in the integrity of these proceedings and the court's duty to remain apolitical. Now, on the other side of this, says Trump's defense, Jack's office cannot advance any principled reason for immediately releasing this appendix. Why? Why do you need it right now? The requested stay will end the public filing of the appendix, so the public will still receive, well in advance of any decision of this court, all the information that they need. It's going to come out eventually, so why now? For the same reason, continuing the stay will not cause Jack any prejudice. Nothing's going to harm him at all. The information it wishes to release publicly will still be released publicly. If you say it's not about the election, okay, it's going to become public. So what does it matter when? Like now or 3 weeks from now? And there's an election happening, so maybe we shouldn't release it right now. Moreover, the special counsel's brief is already in the public domain, despite Trump objecting to that. And Jack represents that the appendix, he says they've already seen the light of day anyways. So he says it's already public, so there's nothing in there. The relief sought herein will not cause any harm to him, but will mitigate a great deal of harm to Trump and the public. And so Trump said, for the reasons that we just described, the court should order its stay to continue through November 14th after the election. Now, at the time of this filing, we reached out to Jack Smith for their opinion on this, and they have not responded. All right, so we don't know what their position is, whether they'll object or not, but it doesn't matter because Chutkan is on a mission like a heat-seeking missile to take out Trump. This got filed 10/17. She immediately responds. She's got nothing else she's doing that day. Responds immediately. She says, all right, guess what? We're not continuing anything. And we are going to be releasing this appendix because that's our final option. Says, here's what Chutkan writes. It's not a long opinion. Says, all right, here's the deal. On October 10th, the court granted leave for Jack to file a redacted version of its appendix, and it issued a stay so that Trump could evaluate his options. Now, as the court has explained, there is an important presumption in favor of public access. Hilarious. So Chutkan the gagger to all facets of criminal court proceedings. Chutkan the gagger is going to now talk about public access, even though she limited Trump from speaking. The court weighed all of the considerations and saying that Trump doesn't follow the factors that are needed to seal. He says Chutkan says none of Trump's arguments are persuasive. Says first, Trump asserts that releasing the appendix now will poison the jury pool, giving us a skewed, one-sided, inaccurate picture. But says no, that's way too speculative to support a stay. Amazing. It's too speculative. They said the same thing. They didn't say exactly jury pool with Trump and his speech, but they certainly said that it would impact other witnesses, right? Other things. Even though he wasn't mentioning anybody by names in those instances. Anyways, so the point is, you can see the pattern developing. When it's information that they want to present to the public, and Trump is trying to limit it due to due process problems, confrontation clause problems, and total violation of his rights, they'll twist themselves into pretzels to stop him. But if it's useful to themselves, they'll publish the hell out of it. They'll gag Trump. They'll object to the, oh, it's too speculative. They suddenly care about the public knowledge. Both sides' filings will be publicly available other than their redactions, but Trump's will have to come after the fact. Whether potential jurors will be exposed to them and in what order is unknown. It's just too speculative. You don't know whether the jury is going to care at all. More importantly, a juror's exposure to information about the case is at best addressed through voir dire, which is the jury questioning, right? It's when you are impaneling a jury and you're asking them questions, which is amazing because why couldn't you do that for Trump's statements, right? They gagged Trump so that he couldn't say anything. Why couldn't you address Trump's statements in voir dire? You obviously could. They just don't want him speaking because they're tyrants. During which the parties and the court can ask individualized questions and probe potential bias or impartiality. Yeah, except with Trump, then Trump is gagged immediately. Second, Trump argues that it's essential for the public to fully understand the arguments and the documents on both sides of this immunity issue and is not misled by one-sided submissions. And that limiting the public's access to only one side of this case would harm its understanding of the case. Here's what Judge Chutkan says. Setting aside the oxymoronic proposition that the public's understanding of this case will be enhanced by withholding information about it, any public debate about the issues in this case, actually it will, because if it's one-sided information, just to be clear about that, if it's one-sided, then they're only going to have one side of it. So you're withholding, Chutkan, you're not withholding it indefinitely. You're just withholding it so that they can be released simultaneously with one another. That's all. So we're not saying that you withhold it indefinitely, but they should come together. Any public debate has no bearing on the court's resolution of those issues. So that's what she says. So basically, I don't care about the election. Legal trials are not like elections. And in any event, the court is not limiting the public's access to only one side. Defendant is free to submit his at any point before the deadline. So just hurry up and just create yours and you can release it too. Each side presents its argument, she says. This is how litigation works, simply how litigation works. So like snotty and condescending. No, it's not actually. It's not simply how litigation works. You're actually twisting the simple mechanics of litigation by your own admission, giving Jack Smith 4 times the page limit and allowing him to file first in a manner that's totally without precedent. So you can't just default. It's just simply how it works. No, it isn't. You're changing how it works right now. Third, Trump contends that asymmetric releases exacerbate the harms that immunity is trying to prevent. Immunity says that you shouldn't have any of this happening. It's a threshold issue that you address first. But the Supreme Court instructed this court to turn directly to briefing addressing the close and fact-specific analysis, right? So she's saying, well, the Supreme Court told me to. And I don't think that's what the Supreme Court said at all. I can't imagine they're happy about it. Those instructions nowhere suggested that the submissions need to be simultaneous, right? So this is that attitude. It's, oh, you want me to take the trash out? You do? All right. I'm going to take the trash out. All right. All right, here we go. I'm taking everything out. I'm throwing that out. I'm throwing that out. I'm throwing that. I'm throwing this out. You throw a temper tantrum, right? You overdo it. Maybe that's not a good example, but you get the point. Oh, you want me to do that thing for you, huh? Sure, happy to do it. You overdo it. That's exactly what she's doing, which is not what the Supreme Court was intending. So the Supreme Court was telling her she can do whatever the hell she wants and violate normal criminal procedure in order to figure out immunity? No, that's not what they said. And indeed, Trump's concern does not appear to be with that, quote, asymmetry, which his own proposed briefing schedule shared. Rather, Trump's objection is to the appendixes released during a highly contested political campaign, she says. Judge writes, but a president's capacity as a candidate for office is unofficial and does not implicate concerns animating his official immunity. Okay, but he's claiming immunity. She is just wild. He's claiming the immunity comes into play based on his prior presidency upon which the charges have been brought. He was a president during J6. He was the president at the time he was communicating with the alternate electors people, so-called, and with his DOJ. Immunity relates back to the time that he was president. And she is so dishonest that she's saying a president's capacity as a candidate for office is unofficial. She's referring to his status now. We're not arguing that. We're arguing that the immunity, so she's crossing the lines, does not implicate concerns animating his official immunity. We're not saying that him running for office right now has anything to do with his immunity. It's not the same issue at all. At all. So accordingly, the court has repeatedly stressed that Trump's concern with the political consequences of these proceedings does not bear on the pretrial schedule. She's conflating multiple things. It's very dishonest. Now, finally and relatedly, Trump claims that the asymmetric release of charged allegations and related documents during early voting creates a concerning appearance of election interference. This is undoubtedly a public interest in courts. There is not inserting themselves into elections or appearing to do, but litigation's incidental effects on politics are not the same as the court's intentional interference on them. Incidental. Are you kidding? This whole case has been a directed, targeted attack at interference. As a result, it is in fact Trump's requested relief that risks undermining public interest. She's nuts. If the court withheld information that the public otherwise had a right to access solely because of the potential consequences of releasing it, Chutkan says that withholding could itself constitute or appear to be election interference. So if I don't release this, then I'll be interfering with the election, which is, I think she's trying to do like a James Comey situation here. I have to publish it. I have to. The court will therefore continue to keep political considerations out of its decision making. It's a joke. This whole case is political. You can see it in the writing here. Rather than incorporating them as Trump requests, any argument about what needs to happen before or shouldn't happen before the election is not relevant here. I don't care. The DOJ brought it. They're not. And she says the DOJ, right? I'm not in charge of the DOJ. If they want to prosecute and not follow their manuals, it's fine. She's written that in prior filings. So for these reasons, Trump's request is hereby denied. In a separate order, the court will lift the stay and direct the clerk of the court to docket the appendix and release these materials with the government's redactions. And so let's see if that has hit the docket at this time. Does not look like it has. And so Chutkan, in one of the more shameful and shameless opinions that we've read from her recently, the clock is ticking. You can sense almost the panic in here as she continues to drop the things that she has in her arsenal to drop. But we'll see what the appendix looks like when it ultimately gets released. Thanks for subscribing and joining us when that coverage continues, and we'll see you back here when it's here.